Welcome to another edition of Inside the War Room. Ryan Ray here, as always, and interesting kind of discussion today. We were following up on kind of some of the shooting stuff we talked about a few weeks ago. I guess it was 2 weeks ago now, around Rayshard Brooks in Atlanta, and reached out through a friend of mine who's an attorney and asked him if he knew someone who might could come on and not maybe break down all of the specifics of the law in Georgia, but just kind of felony murder, how to think about it, stuff like that. And that is how we got our guest today, which is Lane Haygood, who is a criminal defense attorney and former prosecutor. Did I get that right?
You did, yes, sir.
And looking at your resume compared to the friend that sent it to us, I would assume that he's a great guy, but moderate attorney, borderline attorney. Is that how we describe him? Would that be fair? And you seem to be a lot more of an accomplished attorney, so we feel like we got the better end of the deal today.
No, I don't think that at all. I think that Rob has outstripped me in every particular, and good to him for that. I don't have the smarts or the brains to do what he's done.
Oh, he's a good guy. He really is. And so no, as far as I know, great attorney, but always got to give him a hard time. So thanks for coming on. So I will say, first off, so the last time we talked about this case was a couple of days, maybe the next day after the DA came out and has a press conference. And at the time, I think I said on the show, if not, I know I told you, and I said to other people, I do not like the felony murder charge in general. It seems to be too broad, too sweeping. So let's just start maybe from your DA days. Did you ever deploy the felony murder charge? Do you think it's something that we should have? What am I missing? Just help me understand why we have the felony murder charge, and is it actually something that we need?
So, yes, I have prosecuted people for felony murder before. It's really one of those old bits of the law that goes back to the colonial days and the British legal system. The idea is that if someone dies during the commission of an intentional felony, there's this idea that you ought to be able to prosecute the person who is essential in creating the dangerous situation. So the way it's usually used is something like this. You've got people and say they're committing an intentional felony like robbery. So they're robbing a bank, and the two guys who are inside robbing the bank, they've got one guy outside running the getaway car. And so they come out with the money, they get in the car, and they start leading the police on a chase. And at some point, the driver loses control of the car, jumps the median, goes over and hits another car with a little old lady inside, and she dies as a result of the car wreck. Now, in that case, you couldn't charge the getaway driver with intentional murder. He obviously didn't intend to kill the little old lady in the car, but he did intend to create this dangerous situation, and someone died as a direct result of the dangerous situation. So manslaughter seems a bit like weak tea in that situation. And so that's why felony murder exists. It's when you intentionally create a dangerous situation, and as a result of that, someone dies. It's like one of those where we feel like, manslaughter just isn't enough, but it's obviously not intentional homicide.
So help me understand then, is this deployed when people have a DUI and they kill someone? Because wouldn't that at some level be considered the same thing?
It could be, but no, usually that is considered to be a species of what we call involuntary manslaughter. In Texas, for example, we call that intoxication manslaughter. And it's the only type of involuntary manslaughter that we recognize in Texas.
Right. So just real quick, and this would be the problem I'd have with the felony murder charge, is that the first analogy you gave is someone who went out and committed a crime, clearly committed a crime, and I don't want to get into the breathalyzer thing unless you want to, but blood alcohol content debate. But if you have someone who is just really severely drunk, not one tick over the level, and they go and kill someone, it would seem to be that they're actually doing according to the law, at least, something very similar. So that would be the frustration is you kind of get into these nuances. Like, well, I mean,
Sure. And if you could come up with some sort of underlying intentional felony in that situation, you could add a felony murder charge to an involuntary manslaughter. It just, there's a certain amount of discretion and leeway that prosecutors are given in how to bring charges, uh, to kind of tailor them to fit individual situations, because obviously we don't want the legislature out there passing something like California's penal code, which gets super granular and they have a million different offenses. And, if you change this one little fact, you go from sexual battery to sexual assault to
mm-hmm,
aggravated sexual assault,
mm-hmm.
to sexual assault with these factors. I mean, at
Right.
some point, simplifying the law and saying, we trust our elected public servants to use this judiciously is a better outcome than trying to micromanage every aspect of prosecutorial practice.
Yeah. No, I definitely agree that you do want it more simple and not more complex. Okay. So felony murder, you kind of gave us an example. We'll scrap the DUI example just to keep it clear. Okay. So in the example you gave us, just to, and I'm not trying to nitpick the example, just to kind of rehash what was said. There was a bank robbery. They fled the scene. Then they killed the old lady. Now, in this fictional scenario, I don't know how bank robberies last, 2, 5, 10 minutes, whatever. So 15 minutes may have transpired in your kind of fictional scenario, which kind of makes sense on some level under the felony murder deal. There is a felony. The felony has been committed, or we're deep into the felony, and then a murder happens. Um, what what if you walk in, just out of curiosity, in that same example, if you walk in and you go, everybody hands up, and as soon as you say that, some old lady in the corner just falls over and dies because she has a heart attack, or someone kind of run and take the gun, they slip and fall, and and they die some kind of a freak way or something like that. Or is there any way else that this could happen where is the time important, I guess is what I'm asking, because um the case we're going to talk about in a minute was, it's 30, 45 seconds. So does time matter from the time that you commit the felony to the time that the murder happens, or the death happens?
Yes, it absolutely does. So in Texas, in order for the felony murder rule to be invoked, it has to be during the commission of a felony or in the immediate flight therefrom. And the death also has to be proximately related to the felonious conduct. So think of the felony murder rule as this: an independent felony plus someone dies. So the independent felony has to be committed, and it has to be logically and causally related to the death. So if you bust into the bank, pull out the gun, and say, everyone put your hands up, and some old lady has a heart attack, maybe that's an edge case. I
Okay.
mean, you could say, she wasn't going to have that heart attack until you scared her,
Right.
but there would be stuff to argue there. If you go in and someone, tries to run up and take your gun, slips and falls and hits their head, no, probably not. Because even though you're committing the independent felony of robbery there, the independent felony isn't really the cause of the guy's death.
Okay.
The slip and fall was. But in terms of general timing, yes, the death has to occur during the felony or in the immediate flight therefrom. And so that's why, I use the car chase scenario specifically, because that's one from my own past that we prosecuted. Some gentlemen were robbing a bank, and I can't remember if it was a bank inside a grocery store or an independent bank in the town where I was a prosecutor, and fled to the nearest big city. And so they still had police behind them the whole way whenever there was a car accident and someone died. Now, if the police had broken off their chase and these people had driven around later and caused a car accident, that obviously wouldn't be in the immediate flight therefrom. So they would just have, in that case, the reckless driving on one hand and the
Right.
felony robbery on the other.
Okay. No. That's helpful. And again, I don't want to. I'm not trying to pick the analogy. I'm just trying to set the table just to understand. We all like to play lawyer, but you actually are one. So just to kind of get a better understanding. So that's a helpful distinction. Okay. So in the case that we kind of wanted to just kind of reach out and just kind of help us think through was, I guess, have you seen any of the video? You probably heard the story, but have you watched any of the video of the attempted arrest and the tasers and all that? Have you seen any of that, or just kind of heard the stories? Or
I watched a little bit of the bystander video
okay.
the first night. I understand now that the dash cam or body cam videos from the officers has been released. I haven't read that, but I did read the as much of the police reports as has been released to the media. Because in general, I will give this caveat about the media reporting on legal issues. Journalists are not lawyers, but believe themselves to be lawyers. They think that they're experts in everything that they cover. And so they routinely just butcher legal issues. And so media reporting, local media, national media, doesn't matter. Reporting on legal issues is just abysmal all around. So I tend to just go and try to see if I can get the official reports, because even though the official reports are often biased or shaded one way or the other, at least I'm comfortable reading them, and I know
Right,
they're made by people with knowledge of what's in there. So I
right,
feel like I usually get a better picture of what's going on by doing that, rather than watching media videos that may have been edited without my knowledge or
right.
something like that.
Yeah. So just for the listeners out there, anytime we talk about legal issues in the future, just remember that he's talking about us when he says those things. So keep those in mind. No. I'm picking, of course. No, we are not lawyers. And from my perspective, really, there's a couple things. One, there is just, what is the law and how does the law work? But then there's two, the law may or may not be just, and so that's an issue that society has to determine. And so those are things that sometimes we kind of start, talking about, well, this is what the law says, and there's, I don't want to get, I do want to get a jury notification, but we don't have time for jury notification today. But there's a lot of things about that stuff. It feels like we spend time debating it. Okay, so I have watched the body cam footage, unedited 45-minute video. One of them, let me say this: the one that I saw was from the first officer on the scene, and his video camera fell off right before, like, in the scuffle. So if the other one, officers, has been released that actually fired the shot, I have not seen that. It might be out. And I've seen a couple of videos, and then I watched the DH press conference. So most of my comments are based upon that information. And let's just talk really quick, because you mentioned reading the charges. Um, a lot of people, well, my understanding is, since you clarify if I'm wrong, prosecutors, when they're talking to the media, and even through the probable cause hearing, what they're saying there is not necessarily the case that they're going to make,
Correct.
and it might not even be what they really believe the case to be. Would that be an accurate description?
I would say in most cases it is what they think based on the preliminary information, although they may, prosecutors and elected official, they may shade it one way or the other, especially in an election year when they've got something coming up. But these sorts of preliminary matters, the probable cause hearing, magistration, initial appearance, those types of charges that get filed before things go to a grand jury. Because in the United States, no felony charge can be brought without the defendant's permission or except on a grand jury indictment. So whenever prosecutors say that they charge someone with a felony before a grand jury indictment, what they mean is that they filed a complaint and they've sort of set these preliminary charges in motion. But those charges wouldn't support any sort of criminal prosecution until you get the indictment. So a lot of times you'll see prosecutors in a situation like this load up with a bunch of charges to try to get the magistrate to set the bond higher, to accomplish any number of things, to signal to their voters, hey, I'm taking this case seriously. And they may not end up being what the grand jury is willing to indict on. Like, I know in this case, they've got like 4 charges for violating someone's oath as an officer. We certainly don't have anything like that here in Texas. That was totally new to me. The main charge, of course, is a a strange felony murder charge where they're using aggravated assault as the underlying intentional felony, which is permissible. You can do that. It's just not done very often. So it just 11 charges seemed to me like a bit of political posturing on the DA's part in an election year.
Yeah, yeah, just to be clear, maybe rephrase what I was saying. I'm not saying that the DAs do it all the time, every time. It's a tool that they can deploy.
Sure.
And I'm trying to think that there was a specific case, and I think when I talked to you offline, I couldn't remember which one it was, but there was a case where I think it was the one where they burned the family in that house in DC or Baltimore a few years back. Anyways, and you were just listening to the probable cause hearing and kind of what the prosecutors were talking about, what the cops were saying about the evidence, and then when they went to trial, that was not at all how they handled that, and you were like, okay, that was really weird, and I don't know what their motives were or anything. I don't. I think that most people just kind of assume that if the DA is saying it, therefore it must be true, and that is just not true. It could be true. It's just not necessarily true. And so
sure. And like I said, the DA is going to, whenever, and this is why I never, like when I was a prosecutor, if anyone from the media called me, I just said no comment. I don't think that there's anything to be gained necessarily in going out before you have a complete investigation and all the facts and making a statement to the media. But I can see why in that particular instance, the DA in Atlanta felt like, look, if I don't go out there, I'm going to have an angry mob surrounding my building and chunking bricks
right.
and burning me in effigy. So I understand why he needed to make a
Yeah.
statement to the media then.
Okay. So let's get into the case at hand. And this is kind of we see as the non-lawyer, this is my perspective, and then you kind of tell me where I may be right, where I may be wrong, how I'm thinking about it wrong. You just kind of set me straight here. So from my perspective, there's a couple things. One, it does seem that so the whole incident is about 45 minutes, okay, 43 or something. Anyways, and then the last 30 seconds is kind of where everything goes bad. 45 seconds, whatever it is. And it does seem that shooting the man was excessive, and it obviously resulted in his death. Now, with that being said, there's some questions that I have, and I think the felony murder charge is outrageous. But I'm not sure you should be charged anything. That's why I kind of torn, because there's a couple levels here. One, Mr. Brooks turned and pointed the taser at him and was trying to shoot it. We know now that it wasn't going to work because it's been fired twice or whatever, according to the DA at least. So I would imagine that the cops are trained when someone turns and points something at you that is either a gun or a taser or whatever. Your job is to then fire back. Okay, so that would be one thing. So it's like, okay, if that is the training, and I don't know if it is or not, but probably is, it's kind of hard to hold the cop guilty of at least felony murder at that level. The other thing is that the DA said that the cop did not do a proper arrest. Now, I don't know if he's filed a charge on that, but he said that he didn't use the right verbiage, whatever that means. And I thought, first off, I am happy to see people get off because the cops are not following some kind of stupid procedure because they're able to lie to you and all that junk. But I found that very odd that the DA said, well, he didn't use the right verbiage, and so therefore the arrest wasn't valid, which means that everything after that wasn't valid. To me, that seems to be a legal stretch. So I would guess that if the cops do not, they have a lot of leeway on what they can say when they want to detain or arrest you. So kind of getting from, is it as easy for a district attorney to come out and say, well, the cop didn't say, he didn't say you're under arrest for this, and he didn't set the code. So therefore the arrest wasn't valid. Because if that was true, if I'm a defense attorney like yourself, I am demanding body cam footage of every arrest of every person I ever have and making sure that the cops follow the words, and I'm getting guys off left to right. So I don't think that that's actually true. Does that mean, so let's just start there. Can a cop just screw it up? I'm not talking about not reading the Miranda rights. I'm just talking about just by not saying the words right. Is it really that simple?
Not in Texas. Maybe, with this Georgia violation of oath things, they can. But in Texas, we have a law, 3823 of the Texas Code of Criminal Procedure, which says that if there is any illegality in the arrest or the search, then the fruits of that, meaning the arrest or the
Right.
whatever was found in the search, can be suppressed. And so that's really why we do request body cam footage or dash cam footage in every case that it exists. And it obviously doesn't exist in every case. I mean, you know, in the larger cities, yes, every one of those police officers is going to have a body cam, but you get out in some of these small rural towns, they don't have, you know, two quarters to rub together. They're not buying body cams for their sheriff's deputies. But in every case where we can, you can bet we do request it. One, to check to make sure that what the officer puts in his or her report is right.
Mm-hmm.
But two, because you sometimes find great information on there. Like I had a case that I tried back in February where I got the body cam footage from the officers. And as these two officers go and talk, you hear them say that they think that my client should be the one pressing charges because she was the one who had the injuries. And the other lady who was saying she was assaulted, they said, I looked her over. I didn't see a thing on her.
Wow.
So I was able to play that in front of the jury and walk my client right out of that courtroom, an innocent woman.
Wow.
So for sure, you definitely want the body cam footage. Now, how that dovetails with Georgia specific law
Sure.
on this violation of oath and whether there is something in Georgia law that says if the officer violates the oath, it renders the arrest and any subsequent prosecution unavailable, I don't know. I
Right.
mean, I
Right.
just
Yeah. Yeah.
I don't know Georgia law on that one.
No. No. No.
But
So
it
let me.
also could be political posturing by the DA. Again, you know, you want to come out there and if you're setting up this case, me versus the police, then you want the people to think that, well, the police just bungled this from the outset.
Right. And so, just to be clear, what you're saying about Texas would be is if there was it's fruits of the poisonous tree law, is that or kind of got it
Correct.
right? Okay. So if they did something wrong, they had a justified reason to maybe look for an arrest or search your car or whatever, but they didn't handle it properly, and they found like 10 kilos of cocaine because they didn't they didn't do whatever right here. It's the cocaine that's invalidated because they found it that way. It wouldn't necessarily mean that if you and the officer got in a scuffle when they found the cocaine, that the officer would then be guilty of assaulting you because he did something wrong to find the cocaine. Right? That would be the distinction there, correct?
That's correct.
Right.
Because in Texas, our law is that you don't have the right to resist even an unlawful arrest. So even if the police illegally detained you, even if they are illegally searching you and they're putting the cuffs on you for no valid reason, you can beat the rap, but you can't beat the ride.
Uh, that's a good saying. I like that. You can beat the rap, you can't beat the ride. I don't know how that justifies with the Second Amendment, but whatever. It seems like we got a lot of laws in our country that we don't really think through the full implication. But
Oh no,
yeah,
no, 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 no. The legislature is notorious. In fact, that's kind of one of my big areas of practice is getting statutes struck down on First or Second Amendment grounds. So
yeah. I mean, our congressman here, Lang, was wanting to pass something that would make it in Texas a more severe crime to lie to a police officer for if they're like asking for your ID or where you live or something stupid like that.
yeah,
And and so this moron is out there talking about how he's a big Second Amendment guy, and I'm like, well, hold on, wait. Hey, doofus, the Second Amendment is so you can actually carry a gun to fight those people that you are now trying to make it a law to lie against. And I'm not calling for insurrection. I'm not calling for going after the cops with guns. I'm not calling for any of that. I'm just simply saying we have a Second Amendment, we have a First Amendment, which says you have freedom of speech, and then you're trying to say you're for these things while making a law that would actually make it more severe to lie to the cops. And I've never understood how some of the quote unquote conservatives, how they go around saying that they're First, Second Amendment absolutists, and then some of the laws they want to pass. It's like, guys, you I don't think you've ever read those things. But anyway,
just ask them who they think is going to come seize your guns and look under those red flag laws.
I know. Since you got me on that, as an aside, I saw Mike Pence yesterday at the task force meeting, and he was like, they ask about how can Trump hold the rallies, and he's like, well, the First Amendment still exists. I'm like, okay, A, yes, it does. But B, I'm pretty sure that wasn't the Trump administration position 2 months ago. So, or 3 months ago, whatever it is now. So the government likes the Constitution when it works in their favor, and when it doesn't, they just write some other law. But
No, they'll just ignore it.
doesn't
Bulldoze right
exactly
through it.
exactly. So, anyways, okay. So again, Texas, Georgia, we understand that there's differences, but basically, you're from a Texas standpoint at least, not doing a proper arrest. If this were to be Texas, what would have happened to Mr. Brooks is obviously if he wasn't shot, then the breathalyzer may or may not have been admitted. Of course, the breathalyzer was beforehand, so I don't know. Yeah, just help with that. So if there was a fruits of the poisonous tree kind of argument going on because the breathalyzer was before he was detained, that would still be admissible, right?
Well, no, because in this
Nope.
case,
Okay.
it was just a portable breathalyzer, and those certainly aren't scientifically reliable enough to be
Oh,
admitted
okay.
to court.
Okay, I didn't know that. Okay, so okay.
But no, if they had taken him into the station and done the breathalyzer there, or done a blood draw and gotten his blood alcohol content that way, that absolutely would have been suppressed.
Okay. So just as an aside, if I'm hearing you here, if I'm hearing you correctly here as a defense attorney, if you get pulled over and you blow into one of those little cheap ones, what you want to do is spend a lot of time talking and stalling before you go do the official one. Is what you're saying?
Yeah, well, put it this way: if they pulled you over and they're handing you the portable breathalyzer test, or they're making you do the standardized field sobriety test, you're being arrested. So
Okay.
at that point, you should stop giving them any evidence against you and say, "Look, you're going to arrest me, take me to the station." The only circumstance under which I would ever tell a client to provide a breath or blood specimen is if it's in one of those counties where they'll go and they'll get a search warrant for it
Mm.
any time of day or night. And in that case, don't lose your driver's license over it. They're going to get that blood even if you don't agree to it. So just go ahead and provide the specimen at that point in time. But for sure, if they're gonna have you blow into the machine on the side of the road, just say, you know what, go ahead and take me to jail, because there's nothing good going to be gained from you doing the field sobriety test or blowing in that portable breath test.
I don't know how those aren't Fourth Amendment violations, but whatever. That's again. I digress. Okay, so let's get back to our case at hand here. I'll get off on all kinds of crazy stuff. So and what I was asking earlier was, so let's just assume, just for argument's sake, in the state of Georgia, that somehow what he said made the arrest invalid. The scuffle ensues, and then 10, 15 seconds later, um, the, Mr. Brooks points and fires or attempts to fire the taser at the officer. The officer then fires back and kills Mr. Brooks. Um, one of the questions we talked about was the training aspect. For police officers in general. So let's just kind of just step outside of what may or may not be the procedural right or wrong, but just as far as the arrest or not, but just inside of an arrest, if something goes bad and the cop is following procedure, it just for whatever reason the procedure wasn't well thought of, or the procedure just led to this result. Is that a viable out for the cops always? Or is there times where even they should have learned, or they should have known not to follow procedure? And I don't know if it's procedure here or not. I'm assuming
Right.
they are trained to fire if you point at something and shoot it at them.
It's pretty much never an out for them.
Really?
Correct. So each individual department is going to have their own use of force procedure. And there are, of course, model procedures that people can adopt, but by and large, it's up to each individual department. And the law doesn't really contemplate what the department procedure is or isn't. Now, that may be the case if you're trying to hold the police department civilly liable,
Okay.
for adopting a procedure that's just grossly negligent. But the officer's actions are always going to be judged by a reasonable officer standard. So regardless of what the procedure is, would the average reasonable officer put into that officer's shoes in that particular situation have used force?
Okay. To me, I mean, that seems to be a little bit unfair for the officer standpoint, right?
I actually think it's a little more fair for the
Okay,
officer standpoint,
help me.
because
Why so?
what you're doing is you're asking potentially 12 citizens on the jury to take all of the facts of the situation into account and say, yes, it was reasonable in this situation, no, it was unreasonable. Because I think if you try to create too many bright line rules in that situation, you end up saying, okay, but there's so many different scenarios, because as we've seen just talking about this, as we tweak one little thing or the other, it can
Mhm,
totally change the legal
mhm,
landscape
mhm.
of it. So I don't know what the Atlanta Police Department's use of
Sure.
force rules are, or whether this officer complied with them or didn't. I mean, that may be a part of these violations of oath things
Mhm,
that he has in
mhm,
there. But just going at it from a, like, if I'm defending that officer and I'm saying, well, he's acting in self-defense, then the facts that I'm focusing on are the fact that, hey, this guy had a weapon pointed at my client. Did my client know that it had already been discharged and couldn't be fired again? Maybe. But maybe he wasn't sure. And as you said, officers are generally taught, when someone has a weapon and pointed at you, you empty your magazine center mass
mhm.
and worry about the consequences later. Uh, so I think that training is going to become an issue in this one way or the other, because one, this officer is 27 years old. I mean, he's a baby. And two, he apparently has had some use of force issues in the past. So I would assume that he has been given additional training on appropriate use of force. And that would certainly be, if I'm the prosecutor, I'm bringing that up and I'm
Mhm,
saying, like, look, if he got the extra training and still flubbed it, that's bad. But if he flubbed it once before and didn't get the additional training, that's even worse.
mhm,
On the other hand, if I'm the defense attorney, I'm going to say, this guy was going out and he was being given this warrior mindset training at these
mhm.
police seminars, and they basically warped his mind. I mean, the same stuff
Yeah.
that I would do, like if I had a defendant who had been abused as a child as my client, I'd be in there saying, like, look, we never gave him a chance to succeed. He was abused as a child, and his family recruited him into a criminal lifestyle, and
Mhm,
you've got to make allowances for that. So
mhm.
that's why we keep these standards deliberately a little bit vague and a little bit loose, is to leave room for the adversarial system to do its job. And that's where we get our two advocates and we send them to the courtroom and they make their best arguments, and 12 citizens decide who's right.
Yeah, I guess the frustration would be, let me see my the frustration. So I appreciate what you're saying there. I think that's helpful to think about. The frustration from my standpoint would be is, on some level, you could have a police policy in which it is advocating for police brutality, whether it's be a gun or baton or taser, whatever, and the cop follows the policy, something bad happens, and so on some level, I feel sympathetic for him following the policy. Maybe he does know or doesn't know or whatever, but it may not actually bring the change about, because um, the people who wrote the policy or doing the training on some level, they should be held liable. Um,
Absolutely.
and that's kind of the frustration, and that's why I was curious about that, because it's like, well, okay, if he did follow procedure by the book, I'm not saying he did or didn't, and you're saying that that's worth a felony murder charge, well then whoever told him to do that, they have some liability, because he did what they told him. And this is not like a Abu Ghraib situation where he torturing people or something like that. It's a bang bang type deal. So that's kind of the frustration with some of this stuff. It's like, oh, God, and
And I think in that situation, like, if that were my defense as the police officer's defense attorney, then yeah, absolutely, I would be like, look, my guy was just following the policy that was in the books. How can you say that's unreasonable? And I think that juries might resonate with that, because you are a typical juror. You're a non-lawyer. You're
Mhm,
one of the 12 people that I could get to serve on a jury at any time, and so you bring in these beliefs and
right.
these attitudes with you to the jury room. And that's why we have voir dire is such an important process, is because I want to identify people like you. If I'm defending this officer, you're the type of person I want on this jury.
For this trial, Not normally.
Right, right. And
Normally, if you're
that's what,
defending the officer, you don't want me on your.
sure, but that's the thing.
No,
It's
right.
different. It's
Exactly.
different for each trial,
Exactly.
and that's why a good trial lawyer starts off, building their case with picking the right jury. Um, and so with leaving the standards a little bit open like that, it leaves the room for the advocacy and things, because there are ways that you can hold police departments liable civilly,
Mhm.
monetarily, for adopting an unreasonable use of force policy. And that's
Right.
why a lot of them try to stick to these model policies and things like that. And so I can say under the model policies, it probably was not well, in this case, getting to the point where you were in a physical altercation was absolutely the wrong thing to do in this case. So I think that's where the police officers got wrong, was when they started trying to make this physical in the first place, long before weapons were unholstered. So I think that probably factors into the DA's belief that the use of force here was unreasonable and excessive, was because it should never have gotten to the point where tasers or guns were pulled anyway.
Right.
The fact of the matter is, if they had let the guy run off after he got out of the car, they had his car, they knew his name, they knew where he was, they could have towed the car, they could have driven over to his house leisurely and arrested him there.
Right.
Like the
Yeah,
need for a scuffle or physical violence was just not there from the outset.
and that's what the DA says, and so the first time I saw the video, it was like a 4-minute video. And as you said, it was edited, and they wasn't edited to be deceitful. It just cut out like 40 something minutes of them talking to the guy. And so I went and watched the whole thing, and until the guy starts fighting, and then they get the tape. I mean, I say fighting, he's resisting.
Yeah.
They'd already pat him down. They knew he had no weapons on him, or they believed he didn't have any weapons on him. So yeah, that's what I'm saying. I'm not saying that the cop should get off scot-free. It's just that felony murder seems to be the
And
excessive side of that.
the felony murder in this case is, like I said, it's a weird one, because normally you don't see aggravated assault as the intentional felony which underlies
Mm-hmm.
felony murder. I think that in this case, because the DA would have had a choice. He could have gone with felony murder, or he could have gone with manslaughter.
Mm-hmm.
And if you go with manslaughter is obviously the safe choice. I mean, it's pretty much a cut and dried case of manslaughter,
Mm-hmm.
but it's weak tea to a public who is very much aware of police brutality and police excessiveness.
Mm-hmm.
And that's kind of the topic du jour. And so coming in and saying, well, I'm going to play this one safe and take the easy way out. Again, DAs are elected officials, and
Mm-hmm.
that can be a problem. That's one of the reasons the federal system is sometimes a little bit different, is we don't elect our federal prosecutors. So they are somewhat more immune from the passions of their voters, and kind of this, in ancient Greece, what we would call the passions of the mob.
Mm-hmm.
Um, and that can be helpful in situations like this, because they can be a little bit more calm and reflective, versus something like this where the DA almost has to go with the higher charge, the more reaching charge, or face severe electoral or public unrest consequences for going with the safer charge. Now, at trial, obviously manslaughter will still be on the table, because it's a lesser included offense. And
Mm-hmm.
so anytime you have a greater offense, all of the lesser included offenses are on the table for the jury to decide on. And so it could very much be the case that the jury comes back with a manslaughter verdict instead of a felony murder verdict, in which case, the DA can then say, well, hey, look, I presented all the evidence to the jury, and that's what the jury decided, to kind of mollify the public critics. But one factor that I saw when I was looking through the arrest records and the preliminary charges that kind of made me think, okay, well, maybe the DA has the ability to get to felony murder on this one, was the fact that the officers didn't immediately apply first aid.
Right.
And that is a problem. To give you an example from my time as a prosecutor, I had a case where we were prosecuting a gentleman who had just gotten out of prison, and he had immediately gone back to mainlining cocaine. And by the time a drug user is mainlining cocaine, they have hit rock bottom. So he was out driving around, shooting up with cocaine, and an officer saw him run a stop sign or something. I can't remember what it was, but tries to pull him over. And so the guy leads him on a car chase and ends up, popping a curb, going through a yard, running into a house. And so the officer gets out of his car, approaches the car of the drug user, and the drug user puts it in reverse, spins out, lines up with the officer, and guns his engine. So the officer then empties his gun through the windshield, shoots the guy, and immediately runs over and starts performing life-saving first aid, calls for an ambulance. The ambulance brings the defendant to the hospital and patches him up and essentially saves his life.
Oh, wow.
So in that case, the officer, was facing a lethal threat. So his use of force was definitely justified, but his reaction afterward was very important, because if he hadn't gone over and immediately started performing life-saving first aid, that gentleman would have died there. And so in this case, I think it was like almost 2.5 minutes, 2 minutes and 15 seconds, where they held Brooks down and did not perform any first aid on him. And so I think in that situation, that may be what tips off in the DA's mind, like, look, if I go for manslaughter when they did that, then I'm not fulfilling my oath to serve my voters and the public, that they would expect a murder charge on that. And he may very well get there, because that, I think, is conduct from the police that's totally indefensible. Because even if you've just shot someone who you believe seconds ago was trying to kill you, conscientious officers, good officers, and believe me, they are out there, those officers are the ones who would go and immediately try to save the person's life, because DWI isn't a capital crime. It's not that officer's job to be judge, jury, and executioner. They're there to arrest and detain, and if they can save the person's life, then let's leave it up to the court system to mete out punishment.
Yeah, that's a good point, because we had a shooting up here in Dallas, the Amber Geiger trial, which caught a lot of attention.
Right.
And again, it felt like to me that I didn't think it was I'm not a lawyer, so I don't know, but just from just kind of understanding general how charges work and just kind of thinking what's just, it seemed like manslaughter was probably appropriate. I don't know. There was some things that came out in trial that had to be torn, just put like that way. But anyways, one of the problems is that after she shot the guy, she didn't do anything,
Right.
She texted her boyfriend who was married to someone else, and she did all this other stuff except for try to save the guy's life. And in that, whatever you want to say about her being scared or not scared, or whatever you want to believe about anything before that, that is really hard to get past, because you're like, okay, if you were scared, then why are you texting your boyfriend? If you were scared, so and I want to be clear that I understand that people aren't necessarily thinking rationally, but you can't have it that you're deploying cop instincts at point A, but then point B, you were thinking irrationally because you were scared, or your emotions got the best of you, or whatever. And so whether it's this case, the Geiger case, or your case, you have to be careful, because you can't say, well, at least from my perspective, you can't say, hey, listen, I was acting like a cop, and then I got the emotions got the best of me. It's like, well, maybe your emotions got the best of you before too, and so
Sure.
I
No,
think
you're absolutely right there. And that's the thing, is that's why we have the reasonable officer standard. Like you or I, if we're being judged on self-defense, we're being judged by a reasonable person standard, reasonable civilian. Officers, on the other hand, are judged by a reasonable officer standard, because they do have training and experience beyond what the average citizen does. And so in that case, the Geiger case is a good example too. If officers use force and injure someone, they're trained in basic first aid. I mean, they're certainly not emergency medical technicians or anything, but they can be the combat medic right there, and they absolutely should. And not doing that, whether it's because of the adrenaline or whatever's going on, but it kind of reflects on their mental state.
Yeah.
And so a lot of stuff in the law, like the difference between murder and manslaughter, is your mental state. Murder is you intended to cause someone's death, or you knew your actions would cause their death. Manslaughter is you were reckless about it. You were aware of the substantial risk your conduct posed, but chose to disregard it anyway. And of course, we never have any sort of direct insight into someone's mental state. No one's a mind reader. So we have to infer your mental state from all the circumstances that surround your conduct. And so, it looks a lot less like a guilty mental state if you shoot someone and then immediately go and perform life-saving measures on them than if you shoot someone and call your adulterous boyfriend
Right.
and say, hey, I may have messed up. Can you get me out of this?
Right. And in Geiger's case, just as an aside, if she would have shot him, because she said she kind of wigged out, she realized she's in the wrong spot, swept the apartment, and then came in to start applying. If there could have even been a case for a delay there because she realized, and how it is when you think you're drinking a Coke and you have a tea, you're like, wait, something's wrong here. In that case, it's heightened. So there was even an explanation for her to say, well, I swept the apartment and then I put the pressure on. I was like, okay, well, that makes sense because you realized that something was wrong, but that's not happening. So one thing you said a minute ago, I want to get clarification on. You said that, if I understood you, that in the felony murder case, at least, that the underlying charges are there. And it made me think about the Casey Anthony case. I know I don't hate to jump around all these cases, but it's just, as a non-lawyer, it's kind of how you think about things. You're kind of comparing. The Casey Anthony case, she was on first-degree murder. They didn't get that. And then there was some criticism because they didn't go for second-degree murder or manslaughter or something like that. So just out of curiosity, is there anything about first-degree murder, second-degree murder where the underlying charges might not be there? Because I never understood why they didn't have the manslaughter for the Casey Anthony thing, because it seemed like that would be a layup for that one. So, they went for murder. So and maybe it's Florida law, and if it's too much off the track, that's fine. That kind of stuck out when you said that.
No, it absolutely is in the track. So in a criminal case, you have the indictment, which sort of kicks it off, that has the formal charge.
Okay.
And so you indict on one charge. Like if I'm indicting someone on what we call intentional homicide in Texas, or our version of first-degree murder, then I'm indicting someone and I'm saying that, Danny defendant intended to kill Vic victim or took an act clearly dangerous to human life that he knew was certain to result in Vic's death. And so that's my charge. Now, when I get to the end of the case and we've presented all the evidence, then we come up with the court's charge to the jury. And the defense and the prosecutor argue about this all the time as to what you're going to include or what not. And that's whenever you get these lesser included charges in there. Now, if I'm the prosecutor, I might be fighting against a lesser included charge because I'm saying, I think that the jury is going to find this guy guilty, but if I give them the lesser charge, they're obviously going to go for the lesser charge. Okay. Whereas if I'm the defense attorney, I might say, hey, I want that lesser charge in there because it pulls my client's bacon out of some of the fire. But I might also say, you know what? I don't think they're going to convict of the greater charge. So if I fight and keep that out, they may acquit my client rather than convict them of the greater charge. So it's a two-way strategy street there at the end of the case. And I can only assume in the Casey Anthony trial, either the defense attorneys thought, hey, we've beat them on first-degree murder, let's not give the jury an out, or the prosecutor may have been arrogant and thought, hey, I've got first-degree murder sewn up, I don't even need to give them a lesser charge.
I got you.
But yeah, that is for sure.
That, I remember hearing that somewhere, and I don't know how it works, obviously, but that kind of rings a bell that, oh yeah, I kind of remember that. Okay, so that's helpful. So, okay, one of the things that, again, non-lawyer, felony murder, most of the stuff I've seen about felony murder has been either on some TV show. I'm a big fan of The Practice, the early seasons. So
it's the best lawyer show ever.
What's that?
It's the best lawyer show ever, without a doubt.
I mean, when they go into jury nullification in the first episode, I was like, "You've got my heart." Or second episode, anyways. The later seasons are mediocre, but anyways. But felony murder was a big thing on that show. I think they had like 3 or 4 felony murder cases at least. But and then there's some other cases I followed. It just helped me understand, because my understanding, which is non-legal, when I hear felony murder, I think, oh my goodness, you are really up the creek, because that seems to be, in the example with Grandma here, Grandma died. That wasn't in dispute. Your car hit her. That wasn't in dispute. The thing that was in dispute or not was, were you committing the felony? That's how I hear it. So it means that if you were robbing the bank and you were driving the car, then Grandma dying, the murder's the given, the felony's in question. So is that a proper understanding, A? And then B, what kind of defenses can you put up to try to get off of the felony murder charge? Or do you attack the felony? Can you attack the murder? Again, non-lawyer, help me understand.
So A, yes, that is the proper understanding, and then B, you can attack either way. It just depends on what your stronger argument is. If you're attacking the underlying felony, well, then obviously you're trying to say, my client wasn't committing the underlying felony. In the robbery example, that might be kind of hard, but I mean, it can be any intentional felony: arson, burglary, assault, uh, theft, any intentional felony. And so you argue, well, my client wasn't committing felony conduct either at the time of the death or in the immediate flight therefrom. And if you're attacking the murder part of it, you still have to prove causation. So in almost every murder case, you have the identities of the victim and the defendant. I mean, those are set. And then what you're trying to prove as the prosecutor is that the defendant caused the death. And what you're trying to fight against as the defense attorney is my client didn't cause the death. So you have some different avenues there. You can always go with the some other dude did it defense, or you can attack, scientific forms of causation. Like if we were doing the one where the little old lady has the heart attack in the bank, I'm going to have medical doctors lined up
Right,
from
Sam.
here to the end of the
Yeah.
courthouse to come in and testify that, it wasn't my client's fault that she had the heart attack.
Mhm.
And so you can certainly attack the causation there. So if I'm attacking the causation in running from a bank robbery causes a car wreck case, well, I'm going to be looking at, what the other driver did or didn't do, what the police made my client do, like, well,
Was she
they
wearing a
attempted a pit
seatbelt,
maneuver.
maybe? Stuff like that.
Yeah. So, I mean, there's,
There
you
you go.
just attack the causation.
Okay. And could it go from just to help me understand here? So in the bank robber, old lady case, I don't know if that will work out here or not, but maybe it will. Um, the bank robbery is not in dispute. There's video camera, witnesses, et cetera, et cetera, et cetera. The murder on the murder aspect, or no, let me flip that reverse. Can you get off on the felony aspect? So it turns out that you didn't rob the bank, but you did hit the old lady. Can they still get you on manslaughter at trial because the felony part of the felony murder is gone? But
Probably not
okay,
manslaughter in that case, but maybe criminally negligent
okay,
homicide.
okay. So just again, that's what I kind of worked through. So you could get off the felony murder, but
Mhm.
because of the way that argument is structured, but there could be pieces of something that because you might have done something else that you could get maybe the felony side or the murder side, not necessarily murder, but
Right.
yeah. So you could
You're
get
going to have you're going to have two potential lesser included offenses, at least two
okay,
potential lesser included offenses there.
okay. And so just I guess a couple of the questions that won't be around felony murder, but just kind of one more, unless there's anything that you want to make sure that we don't miss because you're the expert here. Have you ever seen a felony murder case where the felony murder or felony murder charge, I guess, that resulted in something that was not the 45 minutes leading up to it, but really just the 30 seconds? That's the felony aspect where the felony is committed, bang, and then someone dies, within seconds later. Have you ever seen it where it's used in such a short time period um, to produce a felony murder charge? Because that would be a question that I don't know. I don't know
Not
what I don't like. And let me say it like this: when you walk into a bank and you stick the gun out and say, everybody freeze. I don't know if you've committed the felony at that point, or if it's just like I don't know how technical the felony thing is. Um, so I'll stop there.
so you've committed robbery at the point where you walk into a bank and you wave your gun and you say everyone freeze. Robbery's been committed, because think of robbery as assault and theft together. So you've committed assault because you've pointed a gun at someone else. That's aggravated assault with a deadly weapon right there. You point a gun at someone, you've committed an assault against them. And you've given them a command and you're about to start robbing them. So you've committed robbery at that point. Uh, if someone doesn't freeze and moves and you shoot them, I don't think that I would charge someone with felony murder in that situation. I'd just charge them with flat out murder.
Right.
Um, so no, normally you see felony murder almost in all cases in the immediate flight therefrom is when
Mm-hmm.
it's used.
Mm-hmm.
Um, because again, if you bring a gun into a bank and you tell everyone to freeze and someone doesn't freeze and you shoot them, I think you intended to shoot that person because that's why you told them to freeze.
Right.
In this case, I don't think that the reason why felony murder was chosen was because there was the aggravated assault and he died as a result of the gunshot, because he didn't die right away.
Yeah.
So I think that those minutes where the officers weren't performing first aid, I think that's why the prosecutor said, okay, I'm going to go with felony murder here. Because if they had, performed first aid and patched him up, at most that's aggravated assault with a deadly weapon.
Mm-hmm. Mm-hmm.
And the fact that they didn't, I think that's where the DA says, okay, I'm going to go for felony murder on this one. Because no, otherwise, like if it had just been, the guy grabbed the taser and ran away and they shot him and they got him in the heart or something like that, that just dropped him right then and there, I think you would have a really, really hard time saying that was felony murder, because either it's just regular old murder or it was manslaughter at that point.
Okay. So just for the non-lawyer perspective, in Texas and probably most places, if I'm understanding correctly, the felony murder charge is typically going to be used, because you've said this a few times now, when a felony is committed, and then you said the flight therein, I think is how you say it.
Yeah,
So
the immediate flight they're from,
yeah.
and it's
So if you
yeah
throw
once
if you light a building on fire and someone's asleep inside and dies, you commit a felony by the arson, but you wouldn't deploy felony murder. Then you just get them for second degree, I guess, right?
if they had no reason to know that someone was inside.
Yeah. Yeah. Right. Yeah. So
Yeah.
They're trying to commit arson, but then turns out there was six people sleeping there. They all died. You wouldn't go, well, you committed a felony, there's a murder. You'd go second degree murder and then the arson charges, right? And I'm just kind of rolling through some examples. If you're
but let's use that arson example. So I set the building on fire and it's like an abandoned warehouse, and unbeknownst to me, there's a homeless guy sleeping inside. Obviously, I would be guilty only of manslaughter in that situation because I didn't know that there was a person in there, although there was a significant risk of that I disregarded. So I'm guilty of arson and manslaughter, which are both second-degree felonies in Texas.
Okay.
Now, let's say that a fireman is responding to my setting the building on fire and rushes in to try to save the homeless guy, and a beam or something falls on him and pins him down and he dies. I am for sure getting prosecuted for felony murder in that situation.
Okay. I see. That's the thing that I knew there were some weird ways that you could get to the murder aspect of it, and I couldn't. So that's helpful to think of, because you wouldn't think of that as murder in the normal sense, but that would be a good example. So, but to kind of go back to where I was at the beginning of that question, more or less, is you don't see felony murder charges on something that happens in 45 seconds, or normally it's usually something a little bit more drawn out over time. I know you got the 2 minutes where they didn't do the first aid. That might be the kind of linchpin to this thing, but it's usually something that's going to be drawn out, where there's multiple steps that are kind of being played out over the course of 10 minutes, 5 minutes, 15 minutes, or whatever, where there's a lot of decisions being employed, and then obviously someone is dying in the result. It's
right.
And I'm not trying to minimize what happened to the man dying. I'm not trying to make light of that at all. I'm just saying it just seems that there's usually more to it than that. So one of the things that I've thought about on this is, so if they get the lesser, as you said, they might get the manslaughter included, but is it a mistake to go for the felony murder charge here? Because, ultimately, instead of coming out and telling the public, hey, listen, what happened's terrible, the law is more likely manslaughter. I don't know. I'm not a lawyer. I'm just making this up. The law is manslaughter. We'd love to get him for murder, but I'm just telling you right now, if it would be refreshing for a DA to come out and say, listen, I'd love to get him for first degree murder or second degree murder or whatever, or third degree in Minnesota, they haven't. I'd love to get him for murder. But the reality is, look, guys, it is not going to happen. We're going to send him out for murder, and he's going to get off, and then you'll be mad. Compared to the felony murder charge, which they may or may not get, and then people are mad because they didn't get it. And so It seems to
Yep.
be almost an injustice for prosecutors to not educate the public more on what the law actually says, like you're doing now with when I really appreciate it, and what they actually can convict people on because we don't know. We as general citizens, we just don't know.
Sure. And I think that comes down to the political acumen of the prosecutor. My former elected boss, who I was working for, certainly had the gift of gab and the personal charisma to go out and to make speeches like that. Uh, there are other DAs that I've worked for that I've met that just don't have that. I mean, they're good, conscientious public servants, but they're not, the level of speechifying that you might see from someone like a Ronald Reagan or a Bill Clinton, who could get a crowd eating out of their hand. And so, to a certain degree, that's politics. And do I think that the DA in this case may have bitten off more than he can chew? It's a certain possibility. I think that there's a if the officer has any amount of good defense attorneys appointed to him, I think that they're gonna have some stuff they can seize on in there, and it may be that the DA was relying on the lesser included offense to save his bacon, or he may just completely overshoot, and the officer may walk, like we've seen happen a couple times with these police violence prosecutions where they got overcharged. And you would hope that a good conscientious DA could go out and educate the public and say, like, look, I've reviewed everything and I understand everyone's frustration. I think this is awful, but if I charge first degree murder, he's going to walk, and that's why I've got to charge manslaughter. Again, I think that comes down to the ability of the public servant to connect with their voters and to make those kinds of statements and be believed and not be seen as a prosecutor running cover for their officers. I mean, it's certainly a situation I do not envy anyone in being in. I can think that my stomach would be churning acid and I would be losing a lot of sleep if I had to make those decisions and to face the public and try and do it. But then again, I think that if you run for DA, you sign up for that.
Right. Right.
And so this DA may have overstepped. I suppose that'll be up to the jury to decide. But I'm not ready as a commentator here to call it one way or the other. Uh,
Sure. Sure.
but yeah, I mean
A lot of
that is
information
a
gotta come out.
definite worry.
Yeah, we do all let me do all the predictions that come out wrong. You give us the reasonableness. No, I know we're up against the clock. Do you have about 10 more minutes? A few quick hitter questions.
Sure, absolutely.
Okay, so just let's just kind of go just a general. Now, this is not legal advice, entertainment purpose only, but it's general, just kind of things that you hear, dispel myths or whatnot. One of the there's a I think it's the Lincoln Lawyer series. I love books, fiction books and crime books and stuff. But anyways, I think it's Lincoln Lawyer. There's a line in there where I think it's the Lincoln Lawyer. Anyways, whatever. There's some lawyer book, and the guy's dad had a saying: "In a pickle, take the nickel." And so if you're in a bind, plead the fifth. Was the point? How true is that for people who are listening? Just as a defense
Absolutely.
attorney, should cop pulls you over? I'll just say this: my personal stance is when a cop pulls me over, he says, where are you coming from? I go right back there. He goes, where are you going? I go right down there. Because I literally had a cop pull me over one time. He's like, where are you coming from? I told him, he goes, where are you going? He goes, da, da, da. He goes, well, we had a car stolen like this like 15 minutes ago. I was like, okay. So I've learned that the cops are not there to ask you questions because they genuinely care. They're asking you questions because they're trying to, whatever they're trying to do. So you get pulled over or you think you're under arrest, general entertainment purposes, air quotes, advice. How should people think about that?
Shut up.
In a
That's
pickle,
all I'd
take the
say.
nickel.
If the cops are doing more than just a general, what we call community caretaking or voluntary police citizen encounter, there's nothing to be gained by telling them anything. If they are looking at you as a suspect, they have their reasons, and you are not going to dispel them with what you're saying. So the best you can say is, you know what? You want to arrest me, but I'm not talking to you. Get me a lawyer.
Okay.
Again, one of those, I can certainly beat the rap, but chances are you're not going to beat the ride.
Yeah, exactly. So, yeah, no, and I think a lot of people go, oh, well, the police is like, listen, the police are there to arrest you. They ain't there to lay.
And I think that's what because and it doesn't have to be this way. One of the things that I'm an advocate for is what we call community-focused policing, where we turn the police from the investigators and preventers of crime back into civil servants, public servant type ideas. And I would certainly like to get back there to where people have that attitude with the police. But based on court cases and the way American law has developed, police have no obligation to protect you, no duty to actually protect and serve. That's a
Yes,
marketing slogan, not a
definitely.
legal principle. Their job is to detect, arrest, and prevent crime.
Mhm.
And so at the point where they are interacting with you, they are doing one of those three things. And the more you talk to them and the more you say to them in that context, the more potential there is for a misunderstanding, because they are trained interrogators and they will get you to trip up. And most people vastly overestimate their ability to give a coherent accounting of their past 5 minutes.
Yeah.
and
Yeah.
and
No,
all sorts of misunderstandings can happen. But no, I have never had a client, one, who has been better off for talking to the police.
and just as an aside, if I were to go back and listen to this podcast, first off, I stuttered, I mumbled from time to time, so you get that, but which cops may interpret as being nervous if you're talking to them. Um, but if I go back and listen to this podcast, there will be a lot of things I'm like, God, why didn't I phrase it that way? Why didn't I just say this? Or, and so this is just a very relaxed interview. If, as the stakes go up, you're more likely to make mistakes. And so,
Oh yeah.
so anyways, so the next thing is just, and I don't know how this works on TV. Bob commits a crime. The defense attorney comes in and goes, listen, don't tell me if you did it. I don't need to know. Is that really how it works? I mean, I've never been, I've been detained in China. So on weapons charges, allegedly. But I've never been detained in the US. So is that really how it works?
So it can be. It depends on if you think that your client is going to need to testify. Because here's the thing: you cannot, as an attorney, suborn perjury. So if I know my client is going to get up there and deny doing what I know he did, I can't ask him questions and get him to make those answers. I would be sponsoring perjury as a lawyer, and that would be a big problem. But if I don't know whether he did it or not, I could put him on the stand and have him say whatever. Now, in general, I do not ever let my clients get near the stand if I can convince them to avoid it. So, I do often inquire to my clients, hey, tell me what's really going on in this situation. But there are some attorneys who, as a matter of tactics, will say, don't tell me, I don't want to know, because I may need to put you on the stand.
Yeah. And just, we hear that a lot. Defense attorneys don't like their clients on the stand, but you hear from jurors all the time going, God, we wish we'd have heard from the defense attorney. How do you reconcile those points of it? Those two things that we hear on the outside is defense attorneys don't like you talking. Juries say we wish we'd have heard from the defendant.
So that means that the defense attorney needs to voir dire that jury better and find jurors who don't have that attitude, because you can get people struck from a jury panel for that attitude.
Hmm.
And the reason why you don't let your client take the stand is your client is 99% of the time an unsophisticated, regular person. And why in the world would you subject them to interrogation by a master interrogator? And almost every prosecutor, if they stay at it for more than a year, gets enough experience with cross-examination that they become very good interrogators. So you're essentially, if you send your client up on the stand, you're putting them in front of the Spanish Inquisition with what, a couple hours prep time with you as to how
Right.
to answer cross-examination questions that they forget the first time the prosecutor makes them angry. So
Mm-hmm.
no, you can have a perfectly innocent person on the stand look guilty by the end of a cross-examination by a skilled prosecutor. So it's just best to avoid that altogether.
So I've often dreamed of, debating or not debating, you know, um, going to trial and arguing a case. But unfortunately, I think California is the only state that allows you to do an apprenticeship. So the only way I think in the United States, maybe some kind of small claims court, I would ever get to defend myself in a real case would be like a criminal defense of myself, which I'm not looking. I don't want that. But it is possible. And I've read sometimes that the sharp defendant in those cases can actually outmaneuver the prosecutor because they're far more concerned about getting off than the prosecutor is about getting them. I have committed no felonies in this case. Anybody's listening that I know of. But just criminal self defending yourself. Is it really as dangerous as people make it out to be? That's just more of a curiosity question because you always, again, this is what's portrayed. Never defend yourself. And it's like, God, I don't mean.
No, that's
something insignificant. You would be more inclined to go after than the prosecutor. What do you think? Now for murder, that might be different.
So if you're talking like a traffic ticket, maybe.
Yeah.
But I always tell people, here's the thing: when lawyers are accused of crimes or things like that, we hire other lawyers. So even, myself, a board certified criminal appellate attorney, longtime criminal defense attorney, longtime prosecutor, if I were accused of a crime greater than a speeding ticket, I'm going to go hire one of my buddies I trust to defend me.
Mm-hmm.
And that's because oftentimes the client is too close to the case to see things objectively, to kind of have that broader perspective that someone one step removed can have. And so I never, ever recommend someone represent themselves because you don't know what your blind spots are.
Okay. And the final question, I guess, is let's talk about that. Not representing yourself versus taking a public defender. Nothing against public defenders. They're obviously underpaid from my perspective and overworked. But I think from the outside public perspective, you think of, well, listen, if I'm in a bind, I'm going to go call the guy with the sign on the billboard. But we sometimes, I guess, we don't really think about the fact that, Johnny Cochran was just probably a better attorney than a lot of people, where that's just because he's more charismatic or he read the law more. I have no idea. Or Jose Baez, who gets off Casey Anthony and some other big name clients.
Yeah.
All lawyers are not created equal, just like all CEOs are not created equal. All engineers are not equal. How do you vet a defense attorney if you're going to try to hire one?
So I really rely on, like, if I'm looking at an attorney to refer a client or something to, I rely first on my firsthand knowledge of watching them as an attorney, and then two, their reputation and their standing in the community. And I think that as a client going out there, word of mouth, talk to people, talk to who the clients are, talk about their experiences, because that to me is worth more than advertising or the bragging and self-promotion lawyers do on their websites. I mean, one of the things that lawyers continually laugh at is something like super lawyers. And I've been a super lawyer for the past couple of years. I don't think that necessarily carries as much weight as the general public thinks they do. It's kind of like one of those who's who clubs where they want you to pay to join. Like, you have to get nominated to be a part of it. But then once you get nominated, they hit you up for a bunch of money so that you can have a plaque and everything. And
right.
I've never done that, but I get emails, oh, you're one of the top 100 criminal defense attorneys in America. Well, thank you for offering, but no, I'm not. Thank you, though. But that's, so all of that kind of stuff is marketing, but you can cut through a lot of that by just talking to people. Hey, when you had that little dust up at the law a couple of years ago, who did you hire? What did you think about them? What did you do? And that's the thing, is I do zero advertising. All of my clients come in by word of mouth and happy clients who I've served well in the past. And to me, that's the ultimate mark of quality in a lawyer, is if the only way that they bring in new clients is good word of mouth, because they're going to go the extra mile to take care of their clients. And lots of lawyers can work hard, but like you said, Johnny Cochran just had that extra bit of charisma. And I think that's what really makes the difference in a criminal defense attorney, is someone who can go in front of the jury and talk to the jury, pick the right jury, and get the jury moving over to their client's side. I think that that's why, um, if someone were coming to me and saying like, look, I need a criminal defense attorney in Georgia, for example. Well, I know a couple of my colleagues who are in Georgia, and so I'd call them up and I'd say, look, I got someone with a DWI in Savannah.
Mm-hmm.
Who would you trust your family to? And I would send them to that person versus going through any number of legal directories or looking at qualifications or law
Right.
schools or cases one or this or that. I want to know from the personal level, who would you trust with your family in their life?
Yeah. No, that is helpful, and it's something hopefully that none of our listeners ever have to go through, but it does happen. And it's I was struck one time. I was watching I don't know if you watched the Making a Murderer documentary on Netflix, but I was watching the defense attorneys talk about kind of not this is season one, not season two, but season one. They're talking about just how they got the case and just their history and all this. And one of them was a public defender before, and he said, he got on the elevator with his wife, and I think it was his wife, anyways. And he goes, "Yeah, this guy came in. He had this stupid story. He's full of it. Da da da. He's guilty, whatever." And then the wife took the case and actually got the guy off. And he goes, he realized at that moment that he wasn't actually doing what he was supposed to be doing. Like he was kind of an eye-opening moment that he's like, oh my, by all accounts, he seems like a pretty skilled attorney, probably pretty good, but he just kind of had lost what his perspective on what his clients were. And that's kind of hard and scary to think that you might have an attorney who's kind of just, okay, got to follow the motion, got to do this, where you want someone who actually believes in justice and trying to make sure that you are being represented fairly. And so anyway, I just wanted to throw that
Yeah,
out there. I was curious.
and that's the thing, vet your attorneys, come in and talk to them. And I often tell people after I'm consulting with them, don't hire me right now. I mean, I've just given you my sales pitch, and yeah, you're all excited to hire me, but you've just heard my sales pitch. Go home, think about it, pray about it, talk to your friends, talk to your family, make sure this is the right decision, because I'll still be here tomorrow. Call me tomorrow after the weekend, whatever, and make that decision. Because ultimately, if someone hires me, I want it to be because they really believe I'm the best attorney for their case, not because they've just sat down for a consultation with me and they've heard me essentially sell myself on them as to why I'm the right attorney to take that case. And I do think that, especially with people in public defenders offices, and let me dispel a myth about public defenders offices. If someone has an actual PDO office, those are by far and away some of the best criminal defense attorneys in America.
Yeah.
A lot of times, like in the smaller counties where I practice, they just appoint us private attorneys, and that's your luck of the draw. You may get the best attorney in the county, you may get the worst attorney in the county. But everyone at the public defender's office generally, because they do it so often, day in, day out, they are some of the finest criminal defense attorneys in America. But they can suffer from empathy fatigue and burnout, just like the rest of us can. And so you do need those periodic reminders from time to time that you shouldn't prejudge any client, that every case is unique and you should listen to them all. And if you find yourself just not believing the client, then you need to take a step back and say, you know what, something or someone is telling me this case isn't for me and it needs to go to someone else.
Yeah, well, and I'll wrap up this. So when I was in China, I had a lock blade pocket knife. I didn't know it was against the law to carry one in public places, and so I didn't end up. I got the ticket over here. It didn't end up being a big deal, but they did kind of. I always say detain me because it's kind of sounds like cool. I was detained on weapons charges, but they took me in the back room and they were talking to me. But there's about 60 seconds because you're kind of waiting on things to be translated. Where I thought, oh my gosh, this might really be a big deal. And I kind of just remember going through all the thoughts of, do I contact the embassy? There's like a 60-second gap between waiting
Yeah.
on, and I'll tell you the story some other time, but kind of waiting on, like, is this a big deal or not? Because there's a long period of time I thought it wasn't. And I was like, okay, this might be bad. And you kind of sitting there going, I was going, okay, how will my wife find out? What am I going to do? Da, da, da. And in those moments, kind of recap some of the things we said. One of the things that I kind of brought into that situation is the U.S. mentality of, I'm not going to say anything because Oh, of course, in China, that might not be how it works. Probably doesn't
Right.
know how it works. But, I kind of had that mentality. Like, they're like, we want you to sign this. Like, no, do I have to sign it? So I got to do stuff like that. And that's probably why it got a little heated. They were perfectly fine as far as that goes. But anyways, but just if I was in the U.S., you can actually speak the language, but you can see how all of a sudden you start to panic, you start to get nervous, you start to talk your way out of it. You're like, oh my gosh! And next thing you know, you said all kinds of stuff that can and will be used against you. And then you're like, I got to find an attorney. And so I think it's just helpful for people just to not plan to be arrested and stuff, but you find yourself at the spot where you are pulled over on the side of the road, or you're in a crowd and something breaks out. Hey, listen, make sure you're being smart about all this. So if people want to reach out to you or have questions, or hopefully they just loved you so much they never need your services, but or do you have a blog or anything that people can follow your work? Or I know you don't and just to be clear, I know you said you don't advertise for listeners. He's doing this out of the good of his heart on a Saturday, so I really, really appreciate this. This is not and you didn't ask to do this, so this is just, and you may not want to do it, I don't know, but I want to give you the opportunity if nothing else.
I don't really have a blog, although sometimes my cases come up on my friend's blog. But if people really want to just follow me and get my thoughts on things, they can follow me on Twitter. I've got a pretty sizable following there. My handle is @HaygoodLaw.
Okay, so Twitter, the other day I was converting my list to followers because the list thing, it works, but it's just not as effective. And so they sent me a thing, said, hey, you can't be adding all these people. I'm like, it's just my list. So I'm on like a 3-day temporary Twitter slap for that. So at Haygood Law, I think I got you right here. Yeah, there you are. So I got you. Okay, good deal. Well, we will put that in the notes as well. Okay, anything else before we get off here that we missed that you want to point out or say that just that got omitted at some point?
Nope, can't think of. Thank you for having me.
Okay, thank you so much for coming on. And to the listeners, we'll be back with another episode here in the next day or so. And so thank you so much, and we'll talk to you soon.